Of course, since the point of these charges isn't actually to enforce the law, but rather to unlawfully and maliciously prosecute a political dissenter for personal gain and at taxpayer expense, dragging the process out as long as possible before their almost inevitable defeat at trial, or more likely, before they drop the charges just prior to trial to avoid being utterly humiliated at trial, such tactics are entirely understandable from the prosecution's perspective. Petition. I have major issues. I have a court date coming up in less than a week. It's a dispositional conference, not a trial or anything. So just talking about how things are going to proceed with regards to the two criminal charges that I'm facing. But because of all the issues, I submitted a motion to the court and to the DA's office for a continuance to have it postponed. And I'll just get into it. I think it'll be self-explanatory. State versus Sean Floyd. Motion for continuance. Petitioner Sean Floyd as defendant in cases CR 24708 and CR 24789 moves to continue any dispositional conference or conferences or other court proceedings regarding these two cases, barring dismissal of either or both, for at least 60 days for the following reasons. Issues with counsel. Immediately after his arraignment on the charge of disorderly conduct on October 9th, 2024, petitioner filled out the form requesting that he be provided with court-appointed counsel and met with the financial screener. Petitioner was very clear from the start that he wished to proceed pro se as his own representative, but be appointed the assistance of that's a typo, obviously, sorry, of a qualified attorney as legal counsel. Section 6 of the Maine Constitution states that, quote, in all criminal prosecutions, the accused shall have a right to be heard by the accused and counsel to the accused, or either at the election of the accused, unquote. At the petitioner's request, the financial screener noted the petitioner's wishes on the form itself. Unfortunately, according to one of the clerks at court, the note was somehow overlooked and the wrong form was used in the process of assigning counsel, and the petitioner was mistakenly assigned counsel as his representative against his express wishes. As a result of this literal clerical error, on December 6, 2024, Jeffrey Toothaker was appointed as the petitioner's representative. The notice was mailed, postmarked on December 12th, and the petitioner received it on or about December 16th. To date, petitioner has been unable to reach this legal representative by mail or phone, and he does not seem to have a publicly listed email address. Furthermore, despite being notified in writing more than 2 weeks in advance, Toothaker apparently failed to appear at the petitioner's dispositional conference on January 14th of this year, the first one. Actually, no, that was the second one. The first one I had continued because I still hadn't been assigned an attorney, basically, and transportation issues. And then the second one he didn't show up for. Now this is the third one, and bit of an update. I did receive about 2 weeks ago a letter from him with his email address on it, and tried to contact him that way. Have not heard a peep back. So I understand. Well, some people say he's shady, and not in a good way, and some people say that he is just super overworked. Either way, you know, I'm not that. An attorney who won't talk to you is not a good legal representative or useful counsel. So all of this basically still stands, I guess is my point there. I submitted this 2 weeks ago, just before receiving that letter from him. So, as I just kind of said there, this does not constitute meaningful legal representation. And in fact, similar and worse issues with such ostensible legal, scare quotes, representatives time after time in the past, such as negligent failure to subpoena or even contact the witnesses for the defense prior to the petitioner's trial, and or gaslighting and openly lying to the petitioner with regards to the law, is exactly and precisely why petitioner invoked his right to act as his own representative in the first place. And of course, the pervasiveness of such problems is why the ACLU is currently suing the state of Maine over its failure to provide indigent people with, court-appointed attorneys that are effective in any way. Petitioner is separately requesting a writ for the appointment of new counsel in the hopes that whoever is so appointed will at least communicate with their client and show up at his court dates. It took roughly 60 days from the time of petitioner's request for counsel on October 9th until Toothaker was appointed on December 6th. Furthermore, given the all too consistent failure of court-appointed counsel to perform even the most basic of duties incumbent upon them, petitioner will need time to verify that certain basic court procedures necessary to the petitioner's defense have actually been carried out by appointed counsel, as well as time to verify the veracity of any information provided by such counsel. And as might be expected, petitioner will require counsel to answer at least a few legal questions, and petitioner will require at least some additional time to verify the veracity of any answers prior to any future court proceedings in order for those proceedings to be in any way meaningful or productive. That's a long sentence, sorry. In fact, if a dispositional conference is held prior to this basic condition being met, petitioner plans to invoke his Fifth Amendment right to remain silent along with his right to self-representation. Issues with the Waldo County Sheriff's Department. The law enforcement agency involved in the criminal mischief charge against the petitioner, case number CR 24789, the Waldo County Sheriff's Department, is refusing to acknowledge petitioner's attempts to provide crucial evidence or to lodge substantive countercomplaints against his alleged victim in this case, or in fact communicate with the petitioner in any way about it. Petitioner, as defendant in the case at hand, will likely need to subpoena documents, files, and information from the Sheriff's Department, who have already demonstrated an unwillingness to share information. Petitioner is pursuing two separate 1983 cases against the County of Waldo and its deputies in federal court. Consequently, petitioner has made multiple attempts to get access to documents, files, and information from the Sheriff's Department under Maine's Freedom of Access Act. The Sheriff's Department has utterly failed to comply with any of these requests in any way. It therefore seems reasonable, given their documented pattern of rights violations against the petitioner and their demonstrable reluctance to comply with requests for information from the petitioner, that the Waldo County Sheriff's Department and its deputies will also likely refuse to comply with any subpoenas issued by the petitioner. If so, petitioner will need to introduce motions to compel them to comply, thus getting information the petitioner needs from the Sheriff's Department in order to meaningfully proceed, barring dismissal of the case, will likely require a significant amount of time. Issues with the Belfast Police Department. The law enforcement agency involved in the disorderly conduct charge against the petitioner, case number CR 24708, the Belfast Police Department, is even more recalcitrant and duplicitous than the Sheriff's Department. In fact, petitioner asserts that this case was brought precisely to avoid providing information regarding the petitioner to be made public. In particular, petitioner was engaging in a blacklisting Belfast PD campaign of protests, visits to public officials, and videos, a campaign of, quote, protesting to the fullest extent of the law, unquote, in order to attempt to force BPD into releasing information regarding an incident from 2023 wherein petitioner was violently mobbed at a public musical event in a Belfast park while a BPD officer stood by and refused to intervene. BPD refused to take any action against any of the individuals who assaulted the petitioner, even though the event was caught on video and witnessed by dozens of people. They then refused to release any information about the incident, even the name of the officer who stood by and watched while the crowd repeatedly physically assaulted the petitioner in response to the petitioner's repeated FOIA, which is Freedom of Access Act, the main version of FOIA, the Freedom of Information Act, request. After the campaign began, BPD did release a few documents to the petitioner, but at least some of these were clearly hastily written after the requests were made or doctored, and were nothing but blatantly transparent attempts to blame the victim, the petitioner, for the incident and claim he was in fact the guilty party because, after repeatedly asking the people violently mobbing him to stop multiple times to no avail, petitioner began using some offensive words to try to get them to stop physically assaulting him, and thus, according to BPD, petitioner had in fact violated the disorderly conduct statute himself as a result. In other words, these folks mobbed me. I asked them to stop several times. They wouldn't. I swore a few times. And then when I requested information about it from BPD, they refused. Then they finally released something that blamed me, claimed I was guilty, the guilty party. The few other additional incident reports they released were similarly questionable, and all but one similarly falsely accused the petitioner of disorderly conduct after the fact. At the time of the actual incidents being reported on in the documents, the petitioner was repeatedly informed by BPD officers, including the officer who eventually summoned the petitioner, that his protests were lawful, and he was never given a warning or summoned for these alleged repeated violations of the statute. The relevance of the above here is that, given BPD's demonstrable pattern of recalcitrance and duplicity, it seems very likely that motions to compel will be required, at the very least, in order to get BPD to release the true and actual files and information which will be being subpoenaed by the defense. Issues with the district attorney's office. As matters of the court's own record, the court may take judicial notice of many of the following facts, and the petitioner avers the remaining ones. In the fall of 2020, just as petitioner was about to finish a 1-year period of probation, petitioner was arrested by deputies Perez and Staples for a fabricated violation of conditions, which was later dropped, and telephone harassment for example, calling Waldo County Deputy Curtis a, quote, worm, unquote, on the phone. Petitioner was able, acting as his own counsel, to secure his release in a few days because the charges were so transparently false. A few weeks later, petitioner was arrested again. This time, it was allegedly for abuse of the 911 system, although petitioner has never dialed 911 in his life to date. But in actuality, petitioner was arrested for characterizing Deputy Staples' previous arrest as a kidnapping of the petitioner. Again, petitioner was able, acting as his own counsel, to secure his release in a few days because the charges were so transparently false. Shortly after this, ADA Entwistle, it's supposed to say, I'm not sure how to pronounce his name, Entwistle, moved for petitioner to undergo a STAT, that's another typo, sorry, it's supposed to say state psychological examination. He then wrote a letter, DA did, to the petitioner's probation-mandated mental health counselor and requested that they stop providing services to the petitioner pending outcome of the exam. Petitioner voiced his very strong objections to this situation, in fact stated at the time that the ADA was planning to use it against him to maim behavioral health. But they chose to comply with the ADA's request for some reason and flatly refused to treat the petitioner until the ADA consented to it. A short while later, petitioner was again arrested. This time, it was while demanding that the Maine State Police answer a few very valid questions about a protection from harassment order. Toward the end of the call, Maine State Police Sergeant O'Rourke admitted to simultaneously being on the phone with ADA Entwistle, and to, quote, checking with him now to see if we can arrest you for separate fabricated condition of the petitioner's release, which isn't really important. They were plotting to arrest me, basically. That's what's important. Eventually, petitioner was arrested for, quote, being very rude to the dispatchers, who had been rude to me and giving me the runaround for 3 days at that point. So I was arrested for being very rude to them, though, at the Maine Communication Center, and ultimately charged with attempted conspiracy to engage in telephone harassment. I kid you not, that's what it came down to, apparently, because of a comment petitioner had made to his YouTube audience about how if any viewers were out of state, then they could legally call the Maine State Police and, quote, harass them, unquote, which is true. Because what constitutes harassment, as I defined it, isn't a federal crime. It's only a state crime in Maine because Maine is so messed up as far as that law goes, especially. Anyway, after this third arrest, the ADA was ready. At the petitioner's bail hearing, Entwistle lied to the judge and plainly stated that Mr. Floyd, quote, Mr. Floyd is refusing to comply with his court-mandated mental health counseling, unquote. Pretty much. I mean, I don't have the transcript, but that's basically, that is what he said. And I have the letter, however, where which he wrote to Maine Behavioral Health and asked them to stop providing me services until further notice. And I have them, Maine Behavioral Health staff, on the phone telling me, yeah, sorry, we're going to comply with it. And me saying, he's going to use it against me, and sure enough. Anyway, since the petitioner had very unwisely agreed to allow the, quote, lawyer of the day, who's just a lawyer that's on hand to help at court in case you don't have one assigned, which I didn't at that time. So I agreed to allow that lawyer of the day to represent me that time around, and since said lawyer completely messed up what petitioner, me, told her while she attempted to secure his release, and since the judge would not allow petitioner to speak and thus correct the record, ironically, the judge was worried that the petitioner might accidentally incriminate himself, the petitioner's bail was revoked this time, which was the plan. Because from there, the ADA was able to coerce the petitioner into a plea deal simply by threatening to hold the petitioner in jail pending the outcome of 3 separate trials and a probation hearing at the height of COVID, when the courts were overwhelmed and with backlogged cases, and that could conceivably have stretched into years of waiting in jail, and as facilitated by the very sophisticated gaslighting skills of the petitioner's attorney at the time, Jeremy Pratt, who misled me about all kinds of stuff to get me to agree to a deal, which, among other things, agree to plead guilty to abuse of the 911 system when I've never dialed 911 in my life. The relevance of the events related above is to point out that ADA Entwistle, presumably with D.A. Irving's blessing, is demonstrably willing to lie, steal, and cheat in order to gain a conviction. And such tactics, especially given that the petitioner is not incarcerated and thus has the resources and time to try to counter them, and will do so as evidenced herein, such duplicitous tactics will likely end up wasting a lot of time. As an example, the ADA's office has repeatedly refused to give the petitioner access to the relevant case files. At first, this refusal was simply de facto. Petitioner was told that he would be granted access, but access was never actually granted. Then, since Toothaker was accidentally appointed as the petitioner's representative by the court on December 6th, the petitioner was refused access by the ADA's office on the grounds that he was no longer his own representative. For a short while after this, the office was still willing to communicate with the petitioner, but on January 17th, ADA Entwistle very unambiguously and expressly ceased communication with the petitioner entirely. Essentially, the ADA's office is capitalizing on a clerical mistake and Toothaker's incompetence in order to thwart and hinder the petitioner's defense, rather than simply making reasonable accommodations / allowances / exceptions to their own policy, because that's not a law. That's what they choose to do. Even more egregiously, the petitioner's alleged victim in the criminal mischief case, in actual fact, accosted, threatened, and recklessly drove to endanger the petitioner, and petitioner was only acting defensively. The petitioner has concrete audio-video evidence of this, but the Sheriff's Department has consistently been refusing to acknowledge the evidence or the petitioner's counter-complaints against the alleged victim from the start. After a 4-month-long campaign of demanding equal protection under the law from the Waldo County Commissioner's Office, attempting to get something like equal protection under the law by unsuccessfully attempting to enlist the help of the DA, that's supposed to be DA-endorsed, Restorative Justice Project. They blew me off. Multiple attempts to get the Sheriff's Department to acknowledge the petitioner's complaints and evidence, and several of the petitioner's YouTube videos highlighting the absurdity of the pending charges got a few thousand views. Spread out over a few videos. And as of the last time the ADA's office was willing to communicate with the petitioner, there has apparently been a change in the situation. Particularly, petitioner was informed by the ADA's office that the petitioner's alleged victim, Thomas Benner, quote, has a new summons, unquote. But a short while later, petitioner was informed that it wasn't a new summons, but that Benner's case is being re-examined and that he has a court date of February 19th. Petitioner suggests that this re-examination and court date could have a very significant bearing on his own case, and thus that continuing any further proceedings until after the February 19th court date and whatever changes to the situation it might engender have time to be processed by the involved parties. Essentially, as is the case with WCSD and BPD, the ADA and or the DA's actions are likely to cause delays, have already caused delays, over the course of attempting to resolve these cases. Of course, since the point of these charges isn't actually to enforce the law, but rather to unlawfully and maliciously prosecute a political dissenter for personal gain and at taxpayer expense, dragging the process out as long as possible before their almost inevitable defeat at trial, or more likely, before they drop the charges just prior to trial to avoid being utterly humiliated at trial, such tactics are entirely understandable from the prosecution's perspective. Petitioner, nonetheless, strongly objects to them. Conclusion. To be clear, petitioner is not trying to put law enforcement agents or agencies or the ADA or DA on trial over any or all of the allegations contained herein. But with the police, prosecution, and even court-appointed defense attorneys consistently failing to fulfill their basic responsibilities, adhere to due process, or even obstinately and frankly pettily and childishly refusing to make reasonable accommodations to the petitioner for the petitioner because of someone else's clerical error, for example, some delays seem almost inevitable. It should be duly noted that none of these issues are in any way, shape, or form the petitioner's fault. This is 10 pages of other people's, the supposed professionals, failing. I'm just a guy. They're accusing of stuff. I don't have the same sort of responsibilities. But I'm adhering to mine. Showing up at court and all that stuff. However, so none is my fault. However, since police, prosecution, and even court-appointed defense attorneys are such unethical actors and apparently insist on proceeding in this recalcitrant manner, petitioner feels that proceeding with extreme caution, with ample time to verify information or go through the necessary process of objecting to unnecessary obstacles, is a fully warranted response, and thus demands additional time as well in response. In summary, a continuance of at least 60 days will allow time for 1. Petitioner to be appointed new counsel and given a meaningful opportunity to discuss the basics of the relevant cases with said counsel prior to proceeding. At least have a chat with my lawyer before we go any further, because, I'm confident I know what's happening as far, like common sense as far as the law goes here, but there's details I don't know, procedures I'm not familiar with. 2. Time for all parties to find out whether the Sheriff's Department and BPD will comply with the subpoenas which the petitioner plans to begin issuing soon. 3. Time for the ADA and or DA to allow the defense to have access to their discovery files. 4. Requests for writs of mandamus to be possibly processed and complied with if items 2 and 3 above fail to happen within a reasonable amount of time. Writs of mandamus are what you do to compel public officials to, do their job, basically. And 5, for Thomas Benner's February 19th court date to occur and have whatever effect it may on the situation. For all the foregoing reasons, petitioner moves to continue any dispositional conferences or other court proceedings regarding these two cases, barring dismissal of either or both, for at least 60 days. And I have here signed it, and the note there says, sent to the DA on 1/24/25, and I initialed it there. And this was also submitted to the court on 1/24/25, so about 2 weeks ago. So the DA or ADA they have a total of 21 days to respond to this, so roughly another week. Unfortunately, it'll be just after my court date, but like I say, that really won't matter a whole lot because I'm probably just going to not say much at that court date. And I don't see how they can reasonably expect me to. Again, these are the supposed professionals carrying on this way. So, yeah, I have a lot of issues. And I also, I have, the same day that I sent these and submitted these, I also sent a couple of more motions, and I'll be covering those in separate videos soon. One for each of the cases, one to include some information, and one to disinclude some information. And hopefully those will be really helpful in me getting a fair trial, or fair trials. I may also combine the two, because side by side it's easier to see the bias. Anyway, or asked to do that. Anyway, thank you all very much for listening. Again, this is, if nothing else for the record, but hopefully, maybe somebody will get something out of it. If nothing else, my story, my side of things here. And, keep fighting, and peace.